fun? Okay, great. Welcome everyone. We are so excited that you're here for this really important event. I want to say a big thank you to Petrie-Flom and the Center for Collaborative Behavior, and specifically Susanna, Lisa, and Laura, who have managed all the logistics of today. It looks like we have a great turnout. There are some seats in the back, and we are going to kick this off. So my name is Stephanie Jabashnik, and I am a forensic psychologist and attorney, and I work at the Center for Collaborative Behavior and the Petrie-Flom Center. I'm also taking some courses at the Divinity School this year, and I see some HDS students in the audience, so great. And I'm joined here by three wonderful people, and I'm going to have you each introduce yourself just briefly. Dr. Robert Kinshirk, we'll start with you. You can use the mic right in front of you.
Hello, I'm Robert Kinshirk. I'm also a forensic psychologist and an attorney and the executive director at the Center for Collaborative Behavior at Mass General Hospital, Harvard Medical School.
And Dr. Melissa Bartholomew.
Good afternoon, everyone. I am Dr. Melissa Bartholomew. I have the privilege of serving as the Dean, Associate Dean for Diversity, Inclusion, and Belonging, and as a lecturer on Diversity, Inclusion, and Belonging at Harvard Medical School. I'm also a lawyer, and I teach restorative justice at Boston College Law School. I'm so excited to be here and to be a part of this conversation.
Hi. I'm Nancy Gertner. I am complicated. I was a criminal defense and civil rights lawyer, then I became a U.S. District Court judge for a number of years. I don't want to give you specific amounts because they don't know my age. And since 2010, I left the bench in 2011. I've been teaching at Harvard. Right now I teach law and neuroscience with Stephanie Jabashnik and with Dr. Robert Kinshirk, and mass incarceration and punishment. And my title is the esteemed senior lecturer.
Thank you. So today we're going to be talking about the sentencing of children. We are the only country in the world that sentences kids to life without parole. Less than 20 years ago, we were executing children. So there's been a lot of work that is being done both on our legal and policy side and on the neuroscience side. So how we're going to sort of proceed today, there's a lot to unpack here, is I'm going to talk about where the law currently is, just briefly, and then I'm going to turn over to Dr. Robert Kinshirk to sort of inform us a little bit about the neuroscience of adolescent brain development and why kids are different from adults. Then we're going to hear from Dr. Bartholomew, who's going to talk about restorative justice and other ways that we can deal with children who harm. Many of these children who harm are also victims themselves, so sort of shifting the narrative in that respect. And then to sort of synthesize everything and unpack everything, we're going to hear from Judge Gertner, who's a retired federal court judge, and tie everything together. And then we're going to have a discussion, and we're really looking forward to your questions and comments. So we're going to have a sizable time to talk about all the information that we are processing today. And lastly, there is going to be a YouTube video recording of this. It's going to be posted in about a week or two, so if anyone is interested in that, then please feel free to sign up for that. And a big thank you to our co-sponsors, many co-sponsors here today, so thank you so much. So we're going to sort of dive in. I know we have a lot of law students here, so you're familiar with the law. And the evolution from sort of where we were, many years ago, when we were, not many years ago, but less than 2 decades ago, when we were not killing, but executing kids, that was Roper v. Simmons. That was a 2005 Supreme Court decision. And what you'll see citations to science and sociological studies. So in this trilogy, the Roper, Graham, and Miller trilogy, what you'll notice, and these are quotes from the Supreme Court opinions, is those references to science, developmental psychology, neuroscience, brain science, and we evolved from first about barring the execution of kids to barring life without parole for non-homicide for kids, and then finally barring mandatory life without parole sentences for juveniles for homicide. Now, in the Miller case, you'll see from the language, it didn't ban life without parole sentences, but it banned mandatory life without parole sentences. So this means in many states, if you commit first-degree homicide, you're automatically sentenced to life without parole. So instead, there needed to be a number of factors that were considered when looking at sentencing a juvenile for a first-degree homicide. And so that was Miller. And then more recently, in 2001, we had Jones v. Mississippi. Okay, and there was a significant change in the constellation of the court here, and you'll see that there was no reference to any sort of science. There was no reference to neuroscience, developmental science, psychology, etc. And what Jones said is that life without parole is permissible for children and only requires consideration of youth as a mitigating factor. In the past several years, we've seen that this doesn't need to be an expansive inquiry into the neurodevelopment or the developmental factors of youth. There just needs to be an acknowledgement of youth. So this was a dramatic departure from Miller and had significant repercussions. So what this did is, between Miller and Jones, a lot of states had codified into their constitutions or into their legislation a ban on juvenile life without parole by virtue of their own bans on cruel and unusual punishment. So when Jones came down the pipeline, it didn't change that, because a lot of these court decisions in the states were based independently on state courts. So right now what we have is each state is grappling with, what does this mean? So can we still sentence kids to mandatory life without parole? Can we still sentence kids, no, but can we sentence them to life without parole with very little inquiry? And in some states the answer has been yes. And in other states, they've expanded the prohibition on life without parole sentences to other age groups, and that is just Massachusetts. So most recently we have Commonwealth v. Mattis, and we have one of the experts, Dr. Robert Kincher, who's one of the experts at Mattis. And Massachusetts took a dramatic step of expanding the prohibition on life without parole to 18 to 21-year-olds based on developmental neuroscience. So if you read this opinion, it's a little bit complicated and lengthy. It was I think a 4-3 decision, and there's there's a number of different opinions to sift through, concurring opinions and so forth, and dissents. But there's a lot of references to science. And so what you'll see here is that this decision was based on state court, okay, and the 8th Amendment. And you'll see references to neurological characteristics, neuroscience, SMRIs, fMRIs, sophisticated brain imaging, and the court says in the majority opinion, the driving forces behind these behavioral differences are the anatomical and physiological differences between the brains of emerging and older adults. So this is Mattis, and other states are grappling with this and have considered banning LWOP for 18 to 21-year-olds. Washington State has gone back and forth with Munchkey and a bunch of other, Anderson and other companion cases, expanding this to 18 to 21-year-old age group, and then sort of backsliding, which has been tremendously interesting. Other states are getting at this through second look acts, where they're saying, okay, after a certain period of time, kids or other age ranges, like under 25, are being looked at for amendments or changes to their sentencing. So this is the overall legal landscape that we're sort of sifting through now with a lot of change. And from here, what we're going to do is we're going to be continuing to think about the legal framework and also integrating the neuroscience. So I'm going to turn this over to Dr. Robert Kincher, and he is going to get us all educated.
So let me show you what had emerged in the science after the development of fMRIs in the late 1980s, 1990s. And I'm fond of quoting one of my colleagues, retired juvenile court judge Jay Glitzman, whose slogan is "Follow the science." But what does the science actually tell us matters in this particular context. So let's take a look at what the data tells us just about normal populations. These are not data from clinical populations or from justice-involved populations. This is just public health data on adolescents in the United States in general, although what I will also add is that this kind of curve that I'll be showing you is replicated in every country in which they have looked at this kind of data. So while there's huge cultural variations, this kind of risk-taking, stimulation-seeking, and so forth appears to be a feature of being a human being rather than a reflection of a particular culture. So What parents and law enforcement and insurance companies have told us long ago, they have more car crashes. Even when you control for a practice effect, they start off with higher crashes. It is not just because they're new drivers, they're also more risky drivers. Many of the insurance companies have known this for a long time, and some states have now incorporated this data into driver license rules that if you get a driver's license at 16, you can't drive unaccompanied with your friends. You have to have not just an adult, but a parent in the car with you until you're 18. So trying to take this into account. They're more likely to have unintended pregnancies. So with the onset of puberty and sexual activity, you see this spike up, and then it begins to drop sharply around 20, 21, 22. Keep an eye on that curve. They drown more often. Spike is at roughly the same ages. You can't see it because of the formatting here, but they drown more often, and then it begins to go down. They attempt suicide and engage in more non-suicidal self-inflicted injury. Watch this spike. With the onset of puberty, just a huge increase in non-fatal self-inflicted injuries, and suicide is now a very common cause of death for persons under the age of 30. But you see it drifts down again. You're more likely to begin experimenting with substances and developing patterns of substance misuse and addiction dependence. This data is a little dated. It's around 2007, but the DSM-5 data looks roughly the same, except for something of a spike that lasts a little longer because of the opiate and fentanyl epidemics. But even that has started to come down. But just look at the enormity of that spike at 15 to 25, and then just down. One thing I want to tell you about this, I want to remind you that only a very small percentage of people in this age range who are misusing substance or actually have patterns of dependence and addiction receive professional intervention. So they're not dropping that curve because they're all getting a lot of substance abuse treatment. It must be due to something else. And while we're here, compared to adults, adolescents and young adults commit more crimes. Now, what I want to show you a little bit here is the correlation of normative adolescents and how it correlates with their functioning in the real world, or as I like to refer to them, my misunderstood customers as free-range chickens. So impulsivity declines with age. Sensation-seeking peaks and then declines with age. Watch these two next ones together. Watch them in tandem. Risk preference is highest in mid-adolescence, but their capacity to perceive risk is lowest in mid-adolescence, especially their capacity to perceive risk as it applies to them. So 16-year-olds are really smart people. And if you ask them, are you safer or less safe if you're in a car driving at high speed with a seatbelt on or off, they look at you like that's a silly question, because it is. And they will say, you're safe if you got the seatbelt on. Are you likely to be healthier or less healthy if you start smoking when you're 15 years old and keep smoking a pack a day until you're 50? They look at you like, okay, another stupid adult question. Yes, I'll be healthier if I'm not smoking. We can go through 25 or 30 public health related questions about health-related risks, and they are all cognitively able to give the answer correctly, but they are also the demographic least likely to translate that knowledge into actual behavior when they are driving, or when they are being sexually active, or when they are thinking about carrying a weapon, or when they are thinking about using drugs or beginning to smoke nicotine and so forth. Thankfully, their future orientation increases with age, and they're more willing to delay gratification. And quite literally, with age, they spend a longer amount of time thinking about hard consequential problems than they do about more trivial problems. I remember talking to a young man shortly after he had been involved in an attempted homicide, and actually this wasn't a homicide case, he was indicted on the felony murder theory, for those of you law students following the baseball scores at home. So he was 14 years old. He was outside in a car. He had agreed to serve as a lookout while his older cousin went inside with a Confederate, and the armed robbery of the convenience store went badly, and the clerk ended up being fatally shot. So I was talking to him, and almost all of my conversations with these young people ultimately boiled down to something like, so what were you thinking? And when did this become a good idea? And he described that he had spoken to his cousin. They had spoken during his lunch break at his high school, and he had been invited to come along with his cousin. He thought that was pretty cool. The cousin was 21, 22. He wasn't asked to do very much with his older cousin, so he thought this was just terrific. And so he described sort of walking home and thinking about this offer to go on this jaunt, and he was thinking about two problems he had to solve. One more immediate, the one for Friday night. The more immediate problem was, when I get home, do I turn on my Xbox and then put my Hot Pocket in the microwave? Or do I put my microwave in my Hot Pocket in the microwave and then go turn on my Xbox? And he was sort of toggling between that thought process and, do I go with my cousin to participate in the robbery of a convenience store and lie to my parents that I'm going to my basketball practice like I usually do on Fridays? Or do I just tell my cousin, no, my parents have grounded me and I don't go, right? So roughly the same amount of mental energy going to solve the Hot Pocket problem, and then do I get involved in a felony problem, right? Thankfully, as they mature, they begin to think more carefully and deeply about potentially quite consequential decisions that they make. I'll depart briefly to just tell you one little anecdote. My son, who had been suspended from school, about something we had talked about very frequently before. And I came home and I found him sitting on the couch, not bothered at all, and sort of playing World of Warcraft. And I was a little surprised to see him because we had this conversation. And I looked at him and I said to him basically, Matt, what could you have been thinking? I had made the mistake of taking him when I taught night school at BU Law, so he knew some of our lingo. And he looked up at me and he paused for a moment and he said, thinking, what was I thinking? Father, I believe you are presuming a fact not in evidence. They also become more resistant to peer influence. I don't like the term peer pressure because I don't think that's how it works. I know very few cases where I've talked to kids who've been involved in very serious bad decisions where they were coerced. Pressure, maybe. Influence is more like they begin talking to each other, and at some point it all emerges as a good idea. And in fact, we know that there are parts of the brain that light up dopamine-rich reward systems in the brain that light up when they even believe that their friends are watching them taking risks, or will hear about it later. That part of the brain doesn't light up when they're alone thinking about risk behaviors, and that part of their brain will not light up at all once they hit about 23, 24, 25. It goes offline because evolution doesn't need it anymore. I wonder what that would be. So these are the kinds of things we just looked at the graphs. These are the normative adolescent development changes as they mature. But the Supreme Court knew all of this for SCOTUS. SCOTUS knew all this at the time of Roper and more clearly by the time of Miller. But there were other questions we wanted to ask and that the courts were asking. There were abortion cases, for example, where Scalia's dissents, I love to read Scalia's dissents late at night when I can't sleep. they just get me going. But he basically asked the question, well, which are they? When it's an abortion case and it's an adolescent making a decision about abortion and whether or not her parents should be involved, they're all contemplative, deliberative thinkers who can take things into account, make very consequential decisions, or are they hot, muddy messes of recklessness and impulsivity, sometimes heavily armed, and they kill people, and you want to kind of build in a brain discount for them that they apparently don't need a brain discount in this other context. And we didn't have research on yet for that yet, but here's what the difference is. It turns out that by 16, most adolescents are as good as most adults in making decisions that are related to competencies to stand trial or medical informed consent. What they remain vulnerable to is executive functioning in conditions of hot cognition, when they're under stress, a sense of immediacy, during high emotional arousal. And if you don't believe me, just look at all the people who have 3.5 grade averages and above, at elite universities who go and do the damnedest things during spring break. Same brain, very different cognitive context for decision making. And this is the punchline. Self-assisting misconduct with maturation, look at where the curve begins to break, 18, 19, 20, 21. And this is self-assistance with social maturation, the adoption of adult roles, and neurodevelopmental maturation. And we see the drop-off in violent and property crime. If you were going to draw a line to catch as many people as possible doing something that they're probably going to stop doing very shortly, you would draw the line of adult jurisdiction at age 18. And if you want more resources on this, there are hard copies of the white paper here at the end. Take one and go home with it. I recommend Pinot, perhaps, as we get into the colder months. But you also have the library, I think this is the library that Stephanie built. This is the CLDB Neuro Law Library, where all of this science information and related legal cases, briefs, law review articles, and so forth are being archived. So I will stop here.
Great, thank you, Robert. So now we're going to hear from Dr. Melissa Wood Bartholomew.
Thank you, Stephanie. It's a privilege to be here, and I appreciate the invitation to talk about restorative justice and how it can be a lens through which we see children differently. Before I begin talking about restorative justice in the context of the criminal legal system, I must begin with some background to foreground the indigenous roots of restorative justice. And I'll do that through discussing my own path with restorative justice as a person of African descent and with Native American ancestry. This is out of reverence and respect. Restorative justice reminds us of the importance of looking back, honoring those who came before us, and remembering that we're connected to them. All those who came before us and those who have yet to come, and those who are here right now. So I begin with the question of what does it mean to live restoratively? Before I learned of the terminology restorative justice, I learned through my ancestral, familial, and faith lineages what it means to live in a way that honors my humanity and the humanity of all others, and that respects all living beings, including all of the natural world. The values that are central to restorative justice: respect, community, humanity, truth-telling, love, restoration, healing, accountability, interconnectedness, have been passed down to me through many generations from my West African lineage as a descendant of Africans who were enslaved in this country. And thanks to Ancestry.com, I know that much of my lineage directs back to Nigeria. And through my native ancestry, specifically through my late paternal grandfather, Reverend Marcus Garvey Wood's maternal grandmother, who was Native American from Virginia. And through my Baptist Christian faith lineage. All of this has been passed down through the generations, and specifically the faith piece through members of my family who are rooted in faith and taught us that we are people of love. We're people made in the image of divine and light and compassion, who believe that we are connected to all humans, that we don't hate even those who oppress us, reinforcing that we are love's vessel, that we are love, that we love our neighbors, that we love all people as we love ourselves, regardless of what they have done or said, but while also holding those who have caused harm accountable, with accountability rooted in compassion. My grandfather, who was a Baptist minister, his paternal grandmother, Susan Wood, was an enslaved woman who was a woman of faith. She was alive while he was a small child, and she taught Grandpa about love. He wrote a book about his formative years in ministry, and he talks about how he learned about love sitting at her feet. She lived until he was about 5 years old. She taught him about the love she had for God, the love she had for her husband, Moses Wood, and her capacity to love and honor the humanity of all people, even those who were oppressors. She did not teach him to hate, even to hate the enslaver. But embodied in that love ethic was accountability and justice. So my grandfather, as a minister, was also engaged in civil rights movement. and the work that was designed to help hold our country accountable for its wrongs and injustices against formerly enslaved people, and advancing the human rights of all, the human rights and the dignity of all. The values of restorative justice are also reinforced for me through my practices of Ifa, a spiritual and cultural belief system originated in the Yoruba division in West Africa and Nigeria that reinforces our connection to nature. All of these cultural principles and values, which are central to restorative justice, highlight our connection to nature, to the divine, to the ancestors, to those who came before us, and those who have yet to be born. And it reinforces a circle consciousness that's been passed down to me through generations. These values are in my DNA. It doesn't mean that I'm perfect or any of my ancestors are perfect. It means that the prevailing valid worldview, orientation, the consciousness that is a consciousness of connection and interconnectedness is one that prioritizes love of all humanity and our connection to each other in the natural world and the divine. It is my foundation. So when I first learned about restorative justice, and I think my origin point is when I began to learn about Rwanda, and specifically the post-genocide restoration work happening in that country, how the country transformed itself through principles of restorative justice and forgiveness. And forgiveness is not a requirement for restorative justice, but restorative justice can create conditions that yield forgiveness. Learning about restorative justice resonated with what had already been embedded in me. I took a course on restorative justice and forgiveness in Rwanda, and it included a 10-day experiential component in the country. And I learned about their reconciliation and trauma healing programming and initiatives, and their Kakata Court community-based system for resolving disputes. Restorative justice is an epistemological site for understanding how love and restoration and wholeness and justice can operate and play out in the world to promote healing and restoration. So it's a proactive approach to changing individuals and environments, and it can also be applied when harms occur. It is fundamentally a way of being in the world. It's a set of principles and practices rooted in indigenous wisdom that is aligned with indigenous cultures all around the globe, and it calls us to prioritize the humanity of ourselves, the humanity of all others, and no one is left outside of the circle. No one, regardless of what they have done or what they have said, lose their right to sit in circle if they have a willingness and openness to engage in the process of accountability through compassion. The circle practices help to operationalize the values that were embedded in me. And it's a way of operationalizing faith principles and spirituality and justice principles that cross faith and cultural divides to make it accessible for all people. I like to say that the circle holds it all and holds us all, and we follow this in the work that I do at Divinity School, the belief that the circle holds us all. Restorative justice reminds us that we acknowledge and affirm the humanity of all living beings, even those who are accused of causing harm. And this is an expression, there's an expression in the restorative justice community that says hurt people, which reminds us that someone who causes harm is likely someone who's been harmed in some way themselves. And they are entitled to be treated with love, compassion, and respect, just like the person harmed. It may look different because they will be compassionately held accountable for what they did, but their humanity will still be honored. All life is sacred, and through restorative justice, we're prioritizing our common humanity, prioritizing the truth that we're all connected no matter what someone does or what someone says. There's always the invitation, the opportunity to sit in circle and to be compassionately held for a process of accountability. So restorative justice calls our attention to honor and respect all living beings, reminding us that we're all connected. It calls us to remember that we're connected to the natural world and to consider the role of the environment and the conditions that contribute to a child's actions. It calls us to consider environmental factors, all kinds of environmental factors, and specifically racism. Restorative justice calls us to examine the role of race and racism in systems and conditions that contributed to a child's actions. And I want to call attention to a book by Fania Davis, Dr. Fania Davis. She wrote a book entitled Race and Restorative Justice. And she wrote this book because people in the restorative justice community were not centralizing the role of race and racism in restorative justice. So racism is an important environmental factor that restorative justice helps us to see. And finally, the work of restorative justice starts with us. The principles and practices will never flourish within a criminal justice system until all of us are willing to engage in the personal practices of self-examination. All lawyers, all judges, all officers, police officers, all of us have to commit to the hard and daily work of self-examination, examining the impact of the environmental toxins, racism, and other systems of oppression, the ways we have internalized these toxins, and the way in which these toxins impact the way we impact and implement the law. There's an expression in Kenya, particularly amongst the Maasai tribe, when they greet one another, regardless of whether or not they have children themselves, their greeting is, "And how are the children?" And how are the children? This greeting is a way that the society prioritizes the humanity of all children. And they believe that a society can be, you can determine the quality of a society by the well-being of its children. So I thought about this as I was preparing for this because restorative justice calls our attention to ask the question, and how are the children? How are the children in this country? It reminds us that regardless of what a child has done, we must look at the factors that contribute to the conditions that created the environment for them to cause the harm that they caused, and that there was some harm likely in some way that contributed to their formation. How are the children being treated? What about children who are less vulnerable? Children who grew up impoverished? Children who grew up exposed to violence daily? Restorative justice helps us to remember that a child, and all people, particularly children, we must always remember that the child's humanity has to be foregrounded. So it reminds us to ask at all times, how are the children? When they come into the criminal legal system, to prioritize their humanity. And the ones who have caused harm, those who have caused harm, we have to appreciate how they got there. So we have to talk about this in the larger context of society. How we treat children and each other is really important. Restorative justice cannot flourish in a system that's embedded in a nation that does not prioritize the well-being of children, the poor, and the least of these. And these are bigger societal questions that also need to be addressed. Restorative justice cannot flourish in a society or within a criminal justice system that is not willing to address and heal from the root causes of racism and everything that separates us. So my call to you, those who are lawyers, those who are studying to become lawyers, is to remind you, whenever you're encountering a case involving a child, to ask yourself, how are the children? How is this child? What are the conditions that brought this child to the legal system? And the work is not only about determining what should happen to this child through a compassionate process of accountability, but looking at the conditions of the surrounding community and what we need to do to change the systems and policies and practices and culture that help create conditions that led this child to come to the contact of the legal system. Thank you.
Thank you, Dr. Bartholomew. That was thought-provoking in the best way. I'm going to turn this over to Judge Nancy Gertner.
I'm supposed to be synthesizing what Dr. Kitcher said and what you said. I have some ideas. Looking at Dr. Kitcher's presentation, and looking at Stephanie's after Sebastian's presentation, one of the things that happened with neuroscience is that it shifted the discussion. In other countries, in other countries, in African countries, in Europe, one can talk about human dignity, one can talk about those kinds of issues, and you can say no life without parole for adolescents, because it offends principles of human dignity. Sadly, we can't talk in those terms in this country. Imagine the argument with the current Supreme Court about human dignity. You'd be laughed out of the courtroom. We don't talk about those terms. But interestingly enough, we could talk about facts. And neuroscience provided facts in a way and changed the discussion about adolescence because it was about facts. Now, there were limits to that, but it was at least about facts. Restorative justice is dealing on a individual level and as well as a systemic level with individual harm and accountability. It should be writ large in the society, but as it is now, is an option that you're beginning to see in criminal legal systems in the country. But it's still not making its way into the criminal legal system writ large. The kinds of things that are informing your presentation are still not making their way there. So there's facts, and then there is the kind of humanity that restorative justice provides. Where does that leave us? As I said, the District Court in Massachusetts has a restorative justice program. I think it's small. The Norfolk Prison has a restorative justice program, but it is relatively small. It's not yet baked into the larger system. So how do we change that? I just want to give a couple of suggestions here. One of the problems with neuroscience, with the fact part of this, is that in fact, the conclusions of neuroscience about adolescent, et cetera, were conclusions about generalities. They were about averages. They were not about individuals. Now, oftentimes I talk to judges, I train judges, and they'll say to me, so what do I do in an individual case? Well, the fact of the matter is, a lot of criminal law is about categories. So what are the categories? One category was life without parole. One category was felony murder for the lawyers in the room, which is the premises of felony murder that hold an individual who participates in a felony accountable for the murder that may have resulted. Doesn't map onto the adolescent brain. Doesn't map onto the adolescent brain who is oftentimes, which is not oftentimes calculating about risk as Robert described, as Dr. Pincher described. So if we're talking about generalities, broad categories, life without parole, felony murder shouldn't apply to adolescents. Solitary confinement has a different resonance when you are an adolescent or an emerging adult than for an adult. So we can look at this category to category. Perhaps we should say we should abolish solitary confinement in general, but especially under 18, especially 18 to 21, especially 21 to 27. The conditions of confinement in general. There's a wonderful scientist, neuroscientist that we work with in our law and neuroscience class, Josh Buchholz, who said, if you wanted to design a prison conditions that would be completely inappropriate for an adolescent or emerging adult who has committed a crime, you couldn't have done better. If you were an evil scientist and you wanted to envision conditions that were absolutely ridiculous for this constituency, you couldn't have done better than our prisons. They make no decisions. Executive functioning is unnecessary. Their life is contained totally, and there are random acts of violence. And under those circumstances, what does that do to an adolescent? So this is a situation where the broad categories of neuroscience can help us look at the conditions of confinement for adolescents. All the men that I sentenced, virtually all the young men that I sentenced for crack cocaine were between the ages of 18 and 27. And like many people in this room know, I'm writing about this and I'm meeting them. And they all shared very similar characteristics. So how do you individualize in sentencing? But more significant, maybe they should not have been in federal court with these charges at all, because they all had trauma. They all, literally all trauma, all flunked out of school, kicked out of school, all had family issues, all had substance issues. So that should lead us to believe maybe we shouldn't have done something, we shouldn't have prosecuted them as we did. How do we deal with these on an individual basis, right? So Robert was talking about categories life without parole in adolescence. How do you deal with an individual? And when I talk to judges, as I said, they'll say to me, how do I apply this to an individual? They're all in, do we say we don't prosecute 18 to 27 at all? No, that's an interesting question. Criminal sentencing, which I teach, is filled with generalizations and tropes from start to finish. Tropes about remorse. If you show me remorse, maybe you won't recidivate, which is preposterous. Tropes about a criminal record. A lengthy criminal record suggests you didn't learn your lessons. It also could suggest chaos in your background, could suggest substance abuse, etc. Maybe we should look at neuroscience in terms of Robert's desistance curve. As I said, the men that I'm interviewing, they didn't need a mandatory minimum of 20 years in order to stop doing what they were doing. If I could map that curve, I mean, sentencing is generalizations, right? You did crack cocaine distribution, you're getting 5 years, 10 years, 20 years. But maybe we could inform those generalizations with these charts so that we understand that you don't need that amount of time in order to stop. We're looking at, you're giving me the book? You don't understand, judges never pay attention to that. Right. Anyhow, I think, so restorative justice focuses, it draws general categories, generalities and general assumptions about what the criminal legal system ought to be. But it's particularly right now, practically speaking, dealing only with a subset of the population. Your presentation suggested it should be much more, but dealing only with a subset. In neuroscience, the question is how can the neuroscience inform the rest of the system? And at least enable a conversation which is unfortunately not about morals and values and dignity, but is about facts. But these are facts that actually can help us all stop it.
Thank you, Judge Gertner. So I'm going to ask a question, but I also want to hear from the audience. So if you have a question, you can raise your hand. And okay, yeah, either one is fine. So in listening to all of you, I was wondering, so we have this adolescent neuroscience that says that kids are different. And for all of these different reasons, kids are different. Is this neuroscience unintentionally sort of solidifying or validating this categorical exclusion of certain people, but reinforcing this other category of people who we're now saying are beyond redemption by virtue of their age? So I was curious about that.
Are we being more strict with over 27 or over 21 because we created an under 21 category?
Yeah, so we're saying, okay, people under the age of 21 are uniquely vulnerable, but is that reinforcing the life without parole punishment or extreme punishment of those who are older?
Yes, I think that's really very interesting. It's almost as if there's a drop-off. The system is enormously punitive, outrageously punitive, ridiculously punitive in the United States. And you're right, we have carved out a subset as to which we are saying we can't be as punitive, but we haven't addressed the rest. So yes, that could well happen. I think then there's a strategic question, which is deploying these resources to at least humanize some part of the system is better than not.
And I think that goes to Dean Melissa's talk. And I'm wondering, how do we humanize? Listening to, I don't know if everyone has this experience, but just listening to you speak, I was feeling better. There was something about just the energy in the room of forgiveness, recognizing humanity, compassion. How do we change the conversation to more of that and less of let's lock them all up?
Absolutely. I hope that what I shared underscored that we can apply restorative justice as a way of thinking, seeing, being in the world, and build capacity in the lawyers that we're training to see the world through this lens, to see justice through this lens. So for instance, there would be no mandatory minimums if the lawyers and policymakers who developed those harsh penalties saw justice for a different lens. So I'm passionate about teaching first-year law students about restorative justice at BC because my colleague and I, Karen Lachinsky, we're developing new lawyers to be, and helping them to see justice in a new way. So we don't have to wait until a model develops in a particular court system. The way you show up as a lawyer, if you embody restorative justice as a way of being, that's going to influence how you decide a case from the bench. That's going to influence how you represent your client. That's going to influence the laws that you make. So it absolutely has to be applied now in law schools, the way we train lawyers. That's the way we change the system. Our classes, restorative justice, transforming the law from within, and the from within is within ourselves. So we believe in the power of transforming individual lawyers, and then they go out into the world to transform the system.
Thank you for that. Robert, did you want to add to that?
I just wanted to add, back to your first question, I just want to observe that we adjust for children all the time. We adjust for youth all the time. We don't let 9-year-olds drive. We don't let 11-year-olds buy as much alcohol as they want. We give people special educational supports that they won't get after age 22. So we adjust for adolescents and younger all the time. The other one is more pragmatic, if you will. And that is, we've been focusing on the extremely long sentences, including life without possibility of parole. But the reality is, almost all the people who are sentenced into prison are going to come back to the communities from which they went. And the average length of time that a young adult defendant spends in a prison is usually not 40 years, is between 5 and 8 or 10 years, depending upon the jurisdiction and crime, which means they're going to come back. And so the conditions of the confinement that they are in during that period of time is absolutely pivotal. And I'll just sort of observe, because I know we're in the United States and we don't like to take other people's ideas, especially if they came from France, but this actually got recycled to us from the Germans, so let's all calm down. The 1947 Model Penal Act, which was never passed in the United States, would actually have created the system that Germany built after the Second World War. They stole this blueprint from us. Juvenile jurisdiction up to age 18, 18 to 26, an entirely separate system that did not rely heavily on incarceration. Incarceration was a really bad look for Germany in 1949. Right? Did not rely heavily, and if you don't get put in with older prisoners, that's your age cohort. They rely heavily on literacy, assistance with language. By the time you're halfway through your system, your sentence, you're going out to do what most Germans do in high school, which is to apprentice, so that when you get out, you have a skilled trade that will allow you to live as a middle-class German. Right? They don't lock them in a box and be mean to them because they know they're coming home. And it's only after you commit a crime at 26, and particularly if you have failed to read the social learning memo, that you're even exposed to a full adult sentence. And even then, their duration of sentences is a fraction of what ours are, and their conditions of confinement are much less punitive. So I think there's a way to take development into account in policy and in representation. I don't think that taking youthfulness into account necessarily results in excoriating those who are further along in the life course development. And I think all of this fits very nicely with the restorative justice approach, especially when almost all the time we're going to have to welcome them back into our communities. So who do you want to welcome back is really the question that we should be asking during this period of time.
Thank you for that, Dr. Ginger. So I want to turn to the audience. Any questions? You could just raise your hand, and I think one of us will run a mic. Any thoughts, feedback, reflections? I think we have a question over here.
I also talk super loud, but well, first of all, thank you so much. I really thoroughly appreciate the presentation. My question, and I think there's an angle for each of you, but specifically in the neuroscience, I'm curious where we see these conversations and what's the next frontier. And I know there's a lot more to be done with children and sentencing, but I'm curious what we think this will unlock in terms of how you think of the justice system overall and where might become the next point that we want to push on using neuroscience or transformative justice and taking those principles and expanding to the judge's point on that doing it somewhere is better than nowhere, and that can become an entry point.
Well, speaking to the science, right now we have the ABCD study, which is generating thousands and thousands of new brain scans of kids across the developmental lifespan. And that's going to be a real game changer in terms of our ability to more understand on a more individual level how kids' brains are affected by poverty, trauma, racism, and all of these other factors. So I think the neuroscience is developing on that front, because right now it's so prohibitively expensive to do brain scans, that a lot of our research is based on small sample sizes. So I think on the science front, that's what we're looking at. We're looking at more animal model studies, especially with substance use and development. But on the legal front, I will defer to the two lawyers, well, three lawyers actually, the two middle lawyers.
I'm not sure that I'm describing what, neuroscience, the field will look at. I can tell you what I would like to see.
Yeah, that's perfect.
Which is, you can persuade judges that this person shouldn't go to prison. There's sort of the prison, non-prison law, and that's a critical one. Judges are not being persuaded enough that that's a critical one, understanding what prison is like. I would like the neuroscience to speak to the question of time. How does the brain, sort of generally, that the longer you stay in prison, the more you acclimate to your environment and the less punishment it is as you go on. Can someone map when there is the most punishment, assuming you want punishment at all, and when it becomes nothing more than warehousing? And I suspect that moment is much earlier than we do. Now again, I would like to say, look at other countries in the world, nobody in prisons as long as we do it. This is outrageous, but this is not a conversation we have in this country. But if we could figure out ways of mapping the impact of imprisonment on this cohort, on anyone, and mapping it in terms of fMRIs, that would be interesting. Again, because we talk in facts.
So I'm going to have Dr. Bartholomew give the final comment of the panel.
I agree with what the judge just said, and I think it can also translate into helping us to be more compassionate. So helping us inform, helping judges understand that the child before them is a human being, and the compassion would then shift their, or even before the judges, going back to the legislators, the laws that are even created, reminding us of humanity. And so the science can help inform that. And when we're rooted in compassion, we're rooted in love, we're rooted in life, it will change the landscape, it will change the way we look at shifting from punishment to restoration and rehabilitation. So there has to be a shift in consciousness, and the science can help us get there.
Thank you for that comment. Thank you so much to our panelists and to our audience members. Thank you so much for coming.
And a reminder for those of you that are going out, if you want copies of the white paper, please feel free.
Yes, the white paper on the science of adolescence.